Hi everyone, I hope the course is going well. I'm just looking at the comments that people have been posting. They're very, very interesting. I'm going to be keeping my eye on them. I'd like to just say a couple of things in overview. First of all, some of the concerns that I've been looking at, I think relate to themes that are coming up a little bit later on in the course, and I'll try and flag those in a later transmission. Other things are perhaps more substantive, some themes that I will try and make some comment on as we go along, because they, I think, chime with themes under the course, or themes that I guess I'm interested in and want to share some ideas with you. One other reminder, there's a chat session this weekend coming up. I hope you can join us for that. Hi, I'm just sat here reading some of the threads from the course, and I'm looking now at Bobo's posting that he put up a few hours ago, which quotes William Blackstone. I think the theme that he's dealing with here, and I'm summarising, it's worth reading in full, is a question I think that comes out of political philosophy. If I try and summarise what the argument is, I'm hoping you can follow me. What Bobo's using is a fragment from William Blackstone. As you know, William Blackstone is a commentator on the common law. And the issue raised is the extent to which one, in a sense, could refuse to be a member of society. I guess the issue is, if laws bind us all as members of society, can we think about how one could choose not to be a subject of law? Now, I said a moment ago, I think this is one of the classic themes of political philosophy. And I think some of the comments that are coming out here take us to this massive debate. I mean, it's a debate, 300, 400 years old, possibly longer. I sense, Bobo, if you're watching this, you've been reading Agamben, because you make a distinction between bare life and sovereign life. I think you probably know your sources here. But for those who are not kind of stuck into this debate in its contemporary way or its historical way, I think what we've stumbled upon, and I think this is great, is the way in which this thinking about law does raise these issues of what society is, what an individual is. Indeed, the final postings, forgive me if I don't mention any further names, but the final postings raise this issue of society. It's as if what we've got here are these two clashing terms, the individual and society. And it seems to me the assumption is that we can think about these terms separately. So my kind of contribution to this would be perhaps the terms themselves are misleading. Perhaps the way in which the debate itself is set up, i.e. this stark opposition between the individual and society, perhaps that's potentially misleading. What if these aren't two separate terms? They're both different ways of thinking about the same thing, i.e. the fact that ourselves, our subjectivity, our sense as legal subjects or as social subjects, comes out of relationality. In other words, you can't think of an individual. The individual is, in a sense, always part of society. It may be that the way the debate has gone has simply misled us, but these strike me as really fundamental questions, and I'm enjoying reading them. I'm reading Elaine's posting on keeping the common law up to date. I think Elaine's asking a really good question here, and it's quite a difficult question for me to comment on, because it covers such a span of historical time and so many detailed themes. I think just to stress 2 points here as to how laws change. I think it takes us to the fundamentals of English law that I'm sure you're all by now at least somewhat familiar with. One way in which the law changes is through parliamentary legislation. Legislating, creating an act of parliament that changes law is obviously a good way of updating the law, repealing old law. It's not the only way. Judges themselves, I think, are lawmakers. There's something of a debate about that. Personally, I think that it's hard to argue that judges don't create law, so let's proceed on the basis that they do. And clearly, in changing the common law on a case-by-case basis, judges are themselves changing the law. I think if you take this question down to a level of detail, we can't do this in the course, but it's something that as a law student you'd be familiar with, and let's say you study a particular area of law, you'll actually see that most of the rules, most of the principles are reasonably recent. It's rare that you come across cases that are from the 1600s or what have you. I mean, some of the time the 1800s or the 1900s, but most modern law, as you could imagine, is fairly up to date because of judicial or parliamentary activity. So a good posting. I hope that clarifies at least some of the points. I'm reading a number of threads on European law. Looks like there's quite a bit of interest on certain themes out there. Certainly, Vatsal Kishore has posted something interesting. There also seems to be a developing discussion between Robert Boatwright, Stephen Cottinger and Fiona Marlies around similar themes. We are going to talk about these in a little more depth later on in this course, but I think I just wanted to really pull out some themes from this very, very interesting discussion. It does obviously, and of course, and this is there in what people are saying, it raises issues about the Constitution, the nature of the Constitution. One of the comparisons that has caused comment online is a comparison, if you like, between the US Constitution and the English or the British Constitution. Let me just remind you of the fundamentals. I suppose one of the key points here is there's no single written constitution in the United Kingdom as there is in the United States. So we have to do constitutional law differently. If we had to talk about the European sources of constitutional law and thus sources of English law, our key point of reference, and I'll talk about this in the lecture, is the EC Act of 1972. Now, I don't want to use the technical language here, although I know that some people are familiar with the language of direct effect and what have you, but let me keep it at a reasonably general level. The idea is because Parliament has legislated in this area by virtue of the UK joining the EU, Parliament has created an act which allows what would otherwise be international law, i.e. binding the nation, not giving rise to rights that individuals could use in national courts. Parliament has passed a law that creates rights that individuals can use in UK courts. It involves discussion of sovereignty, which I will come to later on. My fundamental point here is, and again it's a basic point, but it's a good point, it explains more or less everything that we're concerned with here, is that EU law has effect in British law, in UK law, because Parliament has said so, because Parliament has passed an act saying that EU law creates rights in British courts.